Oh, there you are. Hey, welcome back, class. Welcome back. Thank you for rejoining me again. And thank you for putting up an entire semester of the study of Florida's Constitution. It's impossible to wrap up an entire semester in one presentation. So hopefully you've done more than just this presentation. Hopefully you have conquered the test. What do I got here? I have competed well. I have finished the race. I have kept the faith. I hope that's true for you, both when it comes to the study of Florida's Constitution and when it comes to any worthwhile endeavor that you might do in life. So, in hopes that your studies were successful, I start with just the briefest of prayers. In the name of the Father, the Son, and the Holy Spirit. Amen. Glory be to the Father, to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. In the Father, Son, Holy Spirit. Amen. One of my favorite Catholic prayers, and certainly one of the briefest of prayers, is it not? So what we have for you today is a review for your final exam after having taken my Florida Constitutional Law class. Hey, with any luck, this video will stand the test of time. I'm recording it now, as you know, in April 2020. I don't know when you'll be taking the Florida bar exam, or even if you will be taking it. Perhaps this video could stand this test of time, and when it's time for you to take the Florida bar exam, you can look back at this video and find it helpful to you. At least that's my hope. A caveat, however, a review is just that. Now, this review is a bit dark. Let me see if I get some more light on it. That's a little better. A review is just that. It's a review. It's incomplete. By its very nature, it leaves out certain things, and it includes other things. Now, please don't misinterpret this video as my assurance to you that if I've left it out from this video, I'll leave it out from your final exam. No. There's no such promise. Likewise, don't misinterpret this video to think that if it's on
this video, it's certainly going to be on your final exam. No, again, no such promise. I'm not here to waste your time. I'm not here to play games, but it wouldn't be fair to other students who ran the race and competed well, kept up with the readings and attended all the lectures, to put everything in just one lecture and make all the rest a nullity. Obviously, not fair. I can't do that. But at the same time, let me give you what I believe to be a very thorough review of an entire 2-credit-hour semester of studies. We started our studies, as you remember, on the topic of government transparency and accountability, Florida's sunshine laws, if you will. And pundits opine, I don't know if they have the statistics to back this up, but pundits opine that Florida's sunshine laws are among the broadest, the most protective of Floridians when it comes to comparing Florida's sunshine laws to the government transparency and accountability laws of other states. Allegedly, Florida is more protective. Whether or not that's true, we certainly know that it is more protective than we find under the federal Constitution, even that we find under federal law. Take a look, example, at the Federal Freedom of Information Act. That applies to federal executive branch government agencies, but it doesn't apply to state governments. It doesn't apply to local governments, cities, counties. So FOIA, the Federal Freedom of Information Act, is incomplete. Florida, however, has its sunshine laws. These are texts that appear in the text of Florida's Constitution that are supplemented by what we call enabling statutes. These are statutes that help flesh out and to help bring judicial review to constitutional rights that you see within the text of a constitution. These enabling statutes apply Florida's sunshine law to Florida's state and local governments, as the text of the Constitution alludes and intends. The sunshine law requires transparency and accountability at the state level and at the local level, so it goes farther than FOIA. Government in the sunshine, the Constitution requires it. For example, consider our Bill of Rights, which is the Article 1 Declaration of Rights in our Florida Constitution. There it directly creates in Section 24 a right of access to public records and meetings. Every person has the right to inspect or copy any public record made or received. This section specifically includes the legislative, the executive, the judicial branches. It includes counties. It includes municipalities. It includes any governmental entity. So they are broad indeed. Government of the Sunshine, Florida statutes require it. And as we know from these enabling statutes, there are 3 basic requirements of Florida's sunshine law. First, meetings of public boards or commissions must be open to the public. Second, reasonable notice of such meetings must be given. And third, minutes of the meetings must be taken and properly recorded. There's a message you're giving me. There's a huge glare on the screen. It's hard to read the top left corner. I don't like that either. Thank you for pointing that out. I'm glad that I noticed it. Sorry for the break in the video, but let me take 30 seconds to try to fix that. I'll be back. Chat to me. Did that work? Is the screen any easier to read? Someone yelled Shazam. I think that's a copyrighted phrase. Shouldn't have repeated that. All right, anyway. Okay. Now, where were we? You fixed it. Yes, yay. All right, that's 4 votes for fixed. All right, I'm glad I did something good today. I fixed that. So let me see if I can get my button a little bit closer too. All right. So then, Government of the Sunshine, Florida statutes require it. There's 3 basic requirements of the Sunshine Law. Meetings of public boards or commissions must be open to the public. Reasonable notice of such meetings must be given, and the minutes of the meetings must be taken and properly recorded. How many times am I going to repeat that? Here it is, a 4th time. Government of the Sunshine is a right that is read expansively. It's read broadly by the Supreme Court of the state of Florida. Just a few Quotes from a few opinions illustrate that. For example, in this Florida Supreme Court opinion, Canny versus Lachua, having been enacted for the public benefit, sunshine law should be interpreted most favorably to the public. Here in Palm Beach versus Gradison, sunshine law should be construed so as to frustrate all evasive devices. Imagine you're litigating and you're not getting what you expected from government accountability and from your public records request. How about quoting that? That's going to be powerful, right? Wood versus Marston. Sunshine laws must be broadly construed to advance its remedial and protective purposes. So what we've got here is a law that is designed to be interpreted in favor of the Floridian and designed to be interpreted against the government entity that's trying to avoid accountability, sunshine, and revealing. Where does the sun shine? Or stated somewhat differently, what parts of government are subject under Florida's Constitution to this open records, to this accountability, to these sunshine laws? The legislative, the executive, the judicial? Yes, yes, yes. All three are subject to the sunshine law. Let's take a look first at the legislative. Look at Article 3, Section 4 of Florida's Constitution. Article 3 spells out our legislative branch. In Section 4, it talks about quorum and procedure, and it requires that the rules of each house, the Florida Senate and the Florida House of Representatives, the rules of each house shall provide that all meetings of each house shall be open and noticed to the public. But it doesn't stop there. All prearranged gatherings between two or more members of the Florida legislature, they have to be open. They have to be noticed to the public. It's a routine fact pattern that we see in the Florida bar exam, where you've got a discussion between two elected officials, and you've got to be able to spot the issue. The issue is that all prearranged gatherings between two or more members have to be open, and there has to be notice to the public. Watch out for those issues. Florida's legislature has the power to enact a Florida statute, and that statute can create an exception to public access. So there is a possibility of passing a law that says the sun don't shine, but you can't just do that. You have to meet the constitutional requirements. They are these. First, the law that the Florida legislature passes must specify on the face of the law what the public necessity is for that exception. Second, the law then, after stating that particularized public necessity, must be no broader than necessary to accomplish that particular stated public necessity. And third, the law may contain no other subject matter other than exceptions and their enforcement, a supersized single subject rule, if you will. But notice the power of this. The power of this is that typically good lawyering has a lot to do with whether something is constitutional or unconstitutional. You find the particularized law, you find the standard of review that applies to it, whether it's rational relationship or strict scrutiny, and then you come up, you create, as the lawyer, the evidence that shows the public necessity. That cannot be done here, because here the particularized public necessity has to be found in advance. It's got to appear in the face of the law. If the law is silent, then that law is facially unconstitutional under the Sunshine Law. If it's not silent, then it states a particular public necessity, and that's the only one. That's the limit. That's the only one that the lawyer attempting to uphold and defend the constitutionality of this particular type of law, that's the only public necessity that they can use to try to meet the applicable constitutional standard. So you see here, this makes it more difficult for the government to enact and later to enforce an exception to public access. That was the legislative branch. Does the Sunshine Law also apply to the executive branch? Yes, it does. As to the executive branch and local government collegial bodies. What's a collegial body? That's a government group that makes its decisions by more than one member voting. That's a collegial body. So as to executive branch and local government collegial bodies, any gathering of two or more members to discuss a matter that may foreseeably come before that body is considered a public meeting and must be noticed and open. Again, that's that routine fact pattern we see on Florida bar exam after Florida bar exam. We see two government officials happen to be somewhere and then discuss something. Remember this rule. Any gathering of two or more members to discuss a matter that may foreseeably come before that body, that's a public meeting. It's got to be noticed. It's got to be open. So what's the remedy then? What if there is two or more individuals and they discuss things? Well, there's, as our textbook went over, there's a potential for a fine. There's a potential for misdemeanor conviction. There's a potential for attorney fee award. There's a potential that the law can be struck down as unconstitutional. So it's a serious violation. In general, only two exceptions exist when it comes to sunshine, when it comes to the executive branch. There's a use of staff exception, and there's a fact-finding exception. Both exceptions ultimately turn on the same thing. They ultimately turn on whether there was actual or apparent authority to make decisions. So maybe there was an actual authority to make decisions, but there was apparent authority. If there was, then neither use of staff nor fact-finding is going to be a valid exception to the Sunshine Law's requirements. So there are exceptions, but it's more than just avoiding actual decision-making authority. Even apparent decision-making authority can lead to a violation. So we covered the legislative branch. The sunshine's there. We covered the executive branch. The sunshine's there. What about the judicial branch, the judiciary, the state court system of Florida? Do sunshine laws apply to Florida's judiciary? Yes. Yes, they do. Look at Article 1, Section 24 of Florida's Constitution. That's our Declaration of Rights. When it talks about access to public records and meetings, look at the language it uses. It says, I underlined it for you so you can't miss it, this section specifically includes the judicial branch. So yeah, they're included. Legislative, executive, judicial, all included. One thing we wanted to point out, and we did early on, even before our chapter that was fully dedicated to separation of powers, one thing we wanted to point out, that the separation of powers can be a limitation upon the Sunshine Law. We did that in a lecture that talked about how Florida's legislature is authorized to enforce access and exception via the legislature's own rules. This is an important distinction, as the courts will not become involved in interpreting and enforcing the internal activities of the legislature. So you see that the legislature might violate the text of the Constitution. Thankfully, it's not. But that might not be a justiciable issue. You might not be able to go to court to enforce that. Executive branch and separation of powers. Florida's Sunshine Law does not apply to those powers of the governor and the cabinet that derive from Florida's Constitution. So here's where the separation of powers protects the executive branch. The example I gave a moment ago was separation of powers protecting the legislative branch. Here it is protecting the executive branch. For example, the governor and the cabinet, under Florida's Constitution, they get together as a clemency board. They're required to do that. When the Constitution spells out the way a thing is to be done, then doing that thing in any other way is unconstitutional. So since the clemency board, the board that dispenses pardons, they have their procedures spelled out in the text of the Florida Constitution, but that text doesn't reference the Sunshine Law, then because of separation of powers, the governor and the cabinet are exempt from Florida's Sunshine Law in dispensing pardons and other forms of clemency as authorized by Article 4, Section 8A. The separation of powers we also saw can intrude upon enforcing the Sunshine Law against the judicial branch. We just had an example of the executive branch and the legislative branch, and now we turn to the judicial branch. Under the judicial branch, For example, there's a judicial nominating commission. We talked about this in different lectures. We pointed out how it helps to avoid cronyism insofar as whoever happens to get elected as governor can't just pick a friend or someone they know to be a judge. They have to pick from the list that is sent to the governor by the Judicial Nominating Commission. The Judicial Nominating Commission, how they do their business, that's spelled out in the text of Florida's Constitution. When Florida's Constitution spells out how to do a thing, doing it any other way is unconstitutional. So for that reason, judicial nominating commissions that the Florida Constitution creates for the nomination of Article 5 judges, in other words, state court judges, are not subject to the Sunshine Law. Let's look at structures and powers of Florida's governments. In light of the supremacy of the federal Constitution, what rights do states hold to create and regulate local governments? We found the answer to that question in our study of a 1907 decision of the Supreme Court of the United States called Hunter versus City of Pittsburgh. You remember the powerful language from that decision, which essentially said that neither the United States Constitution nor any laws of the United States control these things. They are controlled by state constitutions. So there is a right to have local governments within the state constitutions, and Florida's Constitution is no exception. If you look at Article 8 of Florida's Constitution, you will see that there is both charter government and non-charter government. So a county, and there are 67 counties in Florida, each inch minutia of Florida land resides within a county, and only one county. That county might have passed a charter, in which case it's a charter government, or it may not have passed a charter, in which case it is a non-charter government. Home rule versus Dillon's rule. What's the difference? Home rule means a municipal corporation. What's that? That's a county, that's a city, that's a town, that's a village. In Florida, that's the Villages. Have you heard of that town? A municipal corporation is an incorporated area of land. So home rule means a municipal corporation can enact a local law unless forbidden. Municipal corporations that have home rule can enact a law unless they're forbidden. Dillon's rule means a municipal corporation cannot enact a local law unless permitted. So the sources of power, home rule versus Dillon's rule, are quite different and quite opposite. Which concept is reflected in Florida's Constitution? Pundits tell us that it is home rule that was intended by Florida's Constitution. Are they right? Are they wrong? Well, if they were so right about it, why did we need Florida's legislature to pass the Municipal Home Rule Powers Act? So whether it's the text of the Florida Constitution or the Florida Municipal Home Rules Powers Act that creates home rule in Florida, we'll let the pundits debate. What we know is that home rule exists either under the text of Florida's Constitution or within the Florida Municipal Home Rules Powers Act. Florida's Constitution, Article 8, talks about lawmaking and its limits. Don't forget that lawmaking is not exclusively the province of the Florida legislature. Under Florida's Constitution, lawmaking can be done by others. For example, those municipal corporations, counties, cities, towns, they can pass laws. Typically, when a law is passed by the Florida legislature, typically it is called a statute. If instead that law is passed by a county or city or town, typically it's called an ordinance. So that's some vocabulary to remember. Regarding non-charter government and charter government, both are referenced in Article 8 of Florida's Constitution. The plain language of the Florida Constitution contemplates that the county will have a governing body. So whether or not you pass a charter, you can still have a collegial body. That collegial body may enact ordinances, laws. They may legislate on topics that might also be addressed by the Florida legislature or a municipality. So look at that in the case of a county. The geographically larger sovereign, Florida legislature might be passing a law on that topic, same topic that the county might pass, unless what? Unless preempted. Remember? Likewise, The geographically smaller municipal corporation, the city, and as you know, under Florida's Constitution, a city must be coterminous and it must reside geographically within a single county's boundaries. So every city resides within a county. If the county's passing an ordinance, a law, can the city pass an ordinance, a law on that same topic? Yes, unless what? Preempted. That preemption might be express or it might be implied. And that preemption might be the result of a county's charter with the supremacy clause, or it might be the result of an ordinance expressly preempting or impliedly preempting. So what we've got here is that a county has a governing body. It enacts ordinances. It legislates on topics that might also be addressed by others. It records such laws so you can find these ordinances, and it names punishments applicable to those who violate them. What about municipalities? Article 8, Section 2 spells out the powers of municipalities. They shall have governmental, corporate, and proprietary powers to enable them to conduct municipal government, perform municipal functions, and render municipal services, and may exercise any power for municipal purposes unless otherwise provided by law. May exercise any power for municipal purposes. We talked about, through several examples, just how low, how weak a standard that is. We've talked about the Municipal Home Rule Powers Act. This is the source of home rule for the non-charter counties and for other entities that weren't expressly granted home rule power within the text of Florida's Constitution. And there we know that municipal purpose under that statute means any activity or power which may be exercised by the state or its political subdivisions. To try to illustrate in the vernacular how weak a standard that is, I use the following, which is not the technically correct constitutional standard, but it's so very close it helps to illustrate it. The vernacular, the non-technically correct standard is, think of municipal purpose as done on purpose. If the municipality did it on purpose, that's almost satisfactory to meet the true technical standard. Therefore, a municipality can act if it's exercising its authority for a valid municipal purpose, and there is no constitutional or statutory limit on the exercise of that authority. Therefore, municipalities can enact legislation concerning any subject matter on which the Florida legislature may act, except, get ready, there's a lot here, except 1, annexation, merger, or exercise of extraterritorial power. 2, any subject expressly preempted by the Florida Constitution or general law. 3, any subject expressly preempted by the Florida Constitution. 4, any subject preempted to a county pursuant to the county charter. Got that? Lawmaking and its limits. The first arrow in your quiver, if you will, the first finding that, if proven, renders the ordinance or statute to be unconstitutional on its face, this is a facial flaw in the statute, would be that it's an improper subject matter. Which are the proper subject matters? Proper for the Florida legislature is any subject that's not preempted by federal law and not forbidden by either the U.S. Constitution or the Florida Constitution. Remember, we think of the Florida Constitution as a limitation upon power. We think of the U.S. Constitution as a source of power. But in either instance, you can be forbidden. You, meaning the Florida legislature, you, Florida legislature, can be forbidden by either constitution. What's proper for a Florida municipality? For a municipality, be it a county or city or town, or any municipal corporation, any subject matter on which the Florida legislature may act, that municipal corporation may pass an ordinance or a resolution also. If done for municipal purpose, talked about how weak that is, except for 1, annexation, merger, or exercise of extraterritorial power. 2, any subject expressly preempted by the Florida Constitution or general law. Or 3, any subject preempted to a county pursuant to the county's charter. The county charter can, but need not, contain a supremacy clause that helps us determine whether or not the subject is preempted by the county charter. So that summarizes, stating somewhat differently, the topics we talked about in the prior slides. Turning now to another arrow in your quiver, if you will, in addition to the proper subject matter, don't forget that ordinance versus resolution, something that requires an ordinance, if passed instead as a resolution, is facially unconstitutional. It's null and void. So with that, we have to understand the vocabulary. What's an ordinance? What's a resolution? An ordinance is something of permanent nature. A resolution is something of either temporary nature or administrative. For example, the speed limit is 35. If that's a law, it needs to be an ordinance. It's permanent. We should start interviewing for a new city manager. If that's a law, that should be a resolution. It's both not permanent and it's administrative in nature. Remember our studies of the case of White versus Town of Inglis. This was the used car dealer case. Remember, the used car dealer was allowing test drives not just on the big commercial street, but on the tiny residential streets, and the residents had enough. Be it resolved, said the Town of Inglis's collegial body, that there shall be a fence blocking the driveway of that used car dealer, so the only way in and out is the big commercial street. The used car dealer tore the fence down. Did he pay the price? Did he suffer the penalty? No, because the local law was unconstitutional on its face. It violated the limits of lawmaking. It was passed as a resolution, be it resolved, even though it was permanent in nature. It was a fence. That illustrated, I hope, that particular arrow in the quiver. Let's look at a third arrow in the quiver, 6 procedural requirements that have to be followed when passing a law, an ordinance, a resolution, a statute. First, notice of intent 10 days prior. Second, publish it in a newspaper, because heck, who reads the internet, right? Publish it in a newspaper of general circulation. Third, required format and statement that's in the notice, follow the statute, copy and paste. Fourth, you can skip 1, 2, and 3 if it's an emergency. You need a 4/5 vote of the collegial body, however, to find an emergency. Fifth, there's no such thing as an emergency when you're messing with the zoning map. And sixth, if you didn't follow these things, it's facially unconstitutional, but there's a statute of limitations or repose. There's a 5-year limitation upon an action for failure to adhere to these requirements. So that's another arrow in your quiver. Let's consider the single subject rule alluded to earlier. What is the single subject rule? Single subject says that a law, in order to be constitutional under Florida's constitution, must address just a single subject and the corollaries of that subject. Why? For considerations such as log rolling, integrity of the legislature. We gave in as an example some quotes from some of the decisions from the Supreme Court of the United States when, in an opinion, they upheld the Affordable Care Act, aka Obamacare. And the justices noted the broad length and scope of the Obamacare, the ACA, and how many pages it was, and how so many things in there had nothing to do with affordable or care. A matter of fact, there was quotes from SCOTUS in their various concurrences and dissents from politicians who were bragging that there was pork in the law. This is one way that a Floridian has greater rights than Americans do. It's some protection from pork. It avoids the log rolling, the attacks on legislative integrity, the buying and selling of votes. Sure, pass my Affordable Care Act. I'll give you some money toward a library. I'll give you some money to build a bridge. Those pork barrel projects that buy votes. The single subject rule is intended to avoid those. The 2 exceptions I mentioned, first is the title. If the law has broad enough title, then that might be written in such an artful way as to bring some seemingly unrelated things under the umbrella of that single title and therefore satisfy the single subject rule. The other exception were those corollaries. And the example I like to give is the Florida Workers' Compensation Law. It spells out the compensation of workers after they get hurt. But then it spells out a separate division within the Division of Administrative Hearings called the Offices of Judges of Compensation Claims. Then it spells out the qualifications to be a judge of compensation claims, or JCC. Then it spells out the budget for the offices of the JCCs. And then it spells out the particular ethics that the judges have to. Wait a minute, what's this got to do with compensating an injured worker? It's a corollary of that single subject. Turning to another arrow in your quiver, amending existing laws. If the law's on the books, are you allowed to amend it? Yes, the legislature can amend, but never solely by reference to the title. But don't forget that exception for repeals of statute by implication that we see in that case of In re Dewood. In order to amend, you have to set out the amended part in full, underline the new text, and use that strike through. Give you an example here. See, there's the underline, there's the strike through. You gotta literally print it up that way. Third, striking of the sunset clause. I'm using some vernacular there. Striking of that clause that says a law expires upon a certain time is insufficient to revive the statute. Can a law have an expiration date? Yes, that's okay under Florida's Constitution. This law is effective until noon on January 31st of a certain year, or any other date and time you might pick. That's constitutional. What if, as that time is approaching, the legislature thinks, well, you know what, we like that law. We'd like to keep it on the books. We don't want it to expire. Can you just print it up and strike out the expiration clause? No, you can't. No, you can't. And a resolution is insufficient to repeal an ordinance. Let's look at another arrow in your quiver, another on its face flaw, another potentially successful attack on the face of a law, the title requirements. Title is not a part of the statute or the ordinance, but it shows intent. The standard here is that the contents are, quote, not inconsistent, quote. I know that's a double negative, but I'm quoting the case law here. This is the literal standard under the case law, that the contents be not inconsistent with the general subject of the title. Remember, you might avoid a single subject rule violation with an artfully drafted, broadly worded title. The title itself is sufficient if the topics are fairly related to it. Again, I'm quoting the case law. That's the constitutional standard, fairly related to it. And the fifth thing to note is the purpose is to give adequate notice of what the law entails. Zoning laws. Zoning laws are what? Are they noise ordinances? No. We're talking about the zoning map. We're talking about the zoning law. Ordinances that pertain to a specific activity rather than the use of the property. Those ordinances are regulations. They're not zoning ordinances, and are thus subject to less stringent notice requirements before passing them into law. Does Florida legislature pass zoning laws? No. That's unconstitutional. That's not a proper subject for the Florida legislature. That's a local law. These zoning laws can't be passed by the Florida legislature, or they're unconstitutional. But the more important thing to note about the zoning laws is the individualized notice is required. I like to make a knocking sound, as if knocking on your door. Remember that in order to own land, you've got to have what? A written deed. That is what? Recorded in the county where the land exists. Knowing that to be true, isn't it true that the county has written records of the current owners of all the land that's going to appear on the zoning map? Of course it is. Of course that's true. So what we require is more than just the 10 days notice run in the newspaper, because nobody has the internet. The 10-day notice run in the newspaper is still required, but what's more, every landowner who's going to be on that zoning map, individualized notice to that landowner is required. There were different inconsistencies that we talked about as arrows in your quiver, as facial, on its face, flaws, where you might attack the constitutionality and you might say that this is a limit to lawmaking. Two types of inconsistency we talked about. One was preemption and one was conflict. Local ordinances are consistent with general or special law unless state preemption precludes a local government from exercising authority, or unless state action expressly conflicts. The first type of inconsistency, the preemption, although state law may continue to prevail over conflicting county laws, regardless of whether the county has a charter, charter county laws can prevail over conflicting municipal laws. They prevail whenever the charter county law is a regulatory ordinance. They also prevail on other topics whenever that supremacy clause in the charter of the county says so. Now, for non-charter counties, county laws do not prevail over conflicting municipal laws. This shows up on exams from time to time, including the Florida bar exam, and I think it's because it might be counterintuitive a little bit, because the county is geographically larger and the city or town or other municipality is geographically smaller. So you might intuitively think, well, the geographically larger one, its laws prevail, but not necessarily so. Look at what we're saying here. The state law might continue to prevail, but charter county laws prevail over conflicting municipal laws in these instances. When the charter county law is a regulatory ordinance, fire code, for example, might also prevail when the supremacy clause says so. But what if it's not one of those things? What if the county's law, its ordinance, is not a regulatory ordinance and it's not referenced in the supremacy clause as having preemption? Well, in that case, despite the geographically smaller size of the city that resides within the county, it's the city that preempts the county. So don't be fooled by the size differential. That's how it works. The last of the arrows in your quiver, so to speak, the limits upon lawmaking. We talked about a different type of inconsistency, a conflict of laws. When do two laws conflict? The test to determine whether there's a conflict is whether you've got to violate one law in order to comply with the other law. So, if your compliance with this law equals a violation of that law, those two laws conflict. A municipality cannot forbid what the Florida legislature has expressly licensed, authorized, or required. So if you can obtain a license to do it from the Florida legislature, then a municipality can't forbid it from being done. That's an example of a conflict of laws. So these are the arrows in your quiver, so to speak. This is lawmaking and its limits. This is facial unconstitutionality, things that any sovereign, whether it's the Florida legislature, the Board of County Commissioners, the City Council, whatever collegial body, they can't violate these restrictions. This is the limits of lawmaking. We also studied Florida's executive branch, and indeed, Florida's Constitution creates an executive branch. It's Article 4 of Florida's Constitution. There you see you have separate elected constitutional officials, including an attorney general, a CFO, chief financial officer, who's also our Department of Insurance head, commissioner of agriculture. Agriculture is big business here in the Sunshine State. State Board of Administration. What do? They're balancing the books and making the investments that constitute the retirement funds of our state employees, among other things. The Internal Improvement Trust Fund, the Land Acquisition Trust Fund, the Department of Law Enforcement, all of them, and their duties spelled out in Article 4, Section 4 of Florida's Constitution. The governor and his powers are spelled out. Among them, in Section 1 of Article 4, he is the supreme executive and commander-in-chief. Commander-in-chief, is this an overstatement? No. Florida has a Florida National Guard. Florida has a right to call up a militia. Definitely, commander-in-chief. Another of the governor's enumerated powers is to initiate judicial proceedings. And third is to obtain advisory opinions from the Supreme Court of Florida regarding his duties. Now, the rest of us, we have to have standing. And we're not entitled to advisory opinions. But the governor, it's among his enumerated powers. He can call it the militia. He can give the State of the State address. It's not like the State of the Union address that the President of the United States gives, but it's the State of the State address that the governor gives. And the governor fills by appointment certain vacancies that come up that would remain vacant within a sufficiently length of time before the next election to fill that seat. We also talked about the powers of the lieutenant governor. He's not the vice president any more than the governor is the president, but by analogy, maybe that helps to explain the lieutenant governor's role. Article 4, Sections 2 and 3 of Florida's Constitution spells out what the lieutenant governor's powers are. He has duties as assigned to him by the governor, or to her by the governor. Also, the lieutenant governor is one heartbeat away from being governor. The lieutenant governor becomes governor upon vacancy or impeachment. Remember a difference in impeachment under Florida's Constitution versus the federal Constitution. Under the federal Constitution, if our chief executive, the President of the United States, is impeached by the U.S. House of Representatives, our president remains president while being tried by the U.S. Senate. Not so under Florida's Constitution. Under Florida's Constitution, if our chief executive, the governor, is impeached by the Florida House of Representatives, then the lieutenant governor, upon impeachment, becomes the acting governor and remains the acting governor while the governor is being tried for impeachment by the Florida Senate. So there's a difference there. Also, upon the docketing of a written suggestion of incapacity of our governor, the lieutenant governor can step up and fill in during that illness or incapacity. In addition to the executive branch, we talked about the judicial branch. In other words, we talked about Florida state courts and judiciary. Perhaps before you went to law school, you didn't realize that there's an entirely separate judicial system from the federal system. Each state has its own state courts, separate and apart from the federal judiciary and the federal courts. Florida is no exception. Article 5 of Florida's Constitution spells out our judicial branch, just like Article 3 of the federal Constitution spells out the federal judiciary. So under Florida's Constitution, Article 5, we see that the judicial power shall be vested in a Supreme Court, in district courts of appeal, in circuit courts, and county courts. No other courts may be established by the state, any political subdivision, or any municipality. How's that for preemption? But don't feel bad for the counties, because each county, all 67, regardless of population, gets a county court. They get at least one, and they get at least one county judge. Depending on population, they may need more than one building and more than one judge, but no less than one for all 67. The legislature shall, by general law, divide the state into appellate court districts and judicial districts following county lines, and indeed, the legislature did that. That's why, although there's still just one Supreme Court, there are 5 district courts of appeal based on county lines. There are 20 circuit courts. And like I mentioned, there's 67 county courts because there's 67 counties. Now, each county is going to fall within one of these 20 circuit courts. A given circuit might have one county, or it might have more than one county. Remember also under Article 5, that's Florida's Constitution's judiciary article, attorneys, admission, and discipline, that's the exclusive jurisdiction of Florida Supreme Court. That's how I make my living, defending my fellow lawyers against ethics complaints, bar grievances. It's great work. Love defending my fellow lawyers. Love helping them. Vocabulary to remember. Circuit court district court. Why is that vocabulary to remember? Because the federal system uses that same language differently than the state system uses it. Remember, when it comes to geographically based jurisdiction appellate courts, we've got 11 federal circuit courts of appeal. They're circuit courts. They're the appellate courts. Under the federal system, when we say circuit court, we're talking about an appellate court. But when we're talking about an appellate court under the state system, we're talking about a district court. First district, second district, third district, fourth district, fifth district. These DCAs, these district courts of appeal. They're appellate courts, but we call them districts, not circuits. In the federal system, we've got 3 trial courts we call district courts. United States District Court for the Northern District of Florida, United States District Court for the Middle District of Florida, United States District Court for the Southern District of Florida. Trial courts primarily and called districts. Our primarily trial courts, although they do have appellate jurisdiction, as we discussed in class, are called circuit courts. And if you can see the map well enough, you can see how these circuits cover the entire state. Now, the hierarchy of Florida's state courts is like a pyramid, isn't it? We've got the Supreme Court of Florida at the top, but you may never get there. As we talked about, our district courts of appeal, the 5 of them, are intended to be the final courts of last resort in most instances. The Supreme Court of Florida has enumerated jurisdiction, but it doesn't have any sort of catch-all jurisdiction, and it certainly does not have certiorari jurisdiction. The United States Supreme Court, the vast majority of its cases falls under that catch-all, if you will, that certiorari jurisdiction. But the Supreme Court of the United States does not have authority under Florida's Constitution. Oh, I misspoke. The Supreme Court of Florida does not have authority under Florida's Constitution to either grant, deny, or even entertain a petition for writ of certiorari. There's no catch-all for the Supreme Court of Florida, anything like there's that catch-all of certiorari for the U.S. Supreme Court. So that's our hierarchy. Article 5 establishes those 67 county courts, 20 circuit courts, 5 DCAs, and 1 Supreme Court. Each has jurisdiction, among other things, to grant or deny certain extraordinary writs. What's an extraordinary writ? It's an original action, by which I mean, although you're in these courts' appellate divisions, you're not there on an appeal. You're there in the first instance. You started the suit. We're not appealing from the prior suit for the vast majority of these extraordinary writs, certiorari being the exception. But what truly makes the extraordinary writs extraordinary is the thing most important to remember. Unlike a lawsuit where if you meet your burden of proof and you identify the correct elements of the action and you prove all the elements of your cause of action. Unlike in a lawsuit where if you do that, you must be granted a remedy, under the extraordinary writs, the remedy is always discretionary, with just one certiorari exception that I'll point out. But what makes them extraordinary is that you can prove your case and still go away empty-handed, because despite proving your case, it's still at the discretion of the court whether or not to grant you a remedy. So the extraordinary writs, one of them is a prohibition. Prohibition action is a means by which to seek a greater court order, preventing a lesser court from doing something that the lesser court should be forbidden to do. Also, a prohibition can be sought against a lesser tribunal or a lesser state actor or local actor that falls within the jurisdiction, the territorial jurisdiction of that greater court. That's a writ of prohibition. Writ of prohibition seeks the remedy of tell them not to do that. In the vernacular, a petition for constitutional writ, sometimes called the all writs power, whether you call it an all writ or a constitutional writ, this type of extraordinary writ is an original action, and it is filed to preserve a court's jurisdiction, as already been invoked, or to protect a court's jurisdiction that will likely be invoked in the future. So a lower tribunal is acting in such a way that is both improper and that would deny the higher court its jurisdiction. So we act now to stop that lower court or tribunal from taking that action in order to preserve the higher court's jurisdiction. Where do we file it? In that higher court, whose jurisdiction we need to preserve. The writ of quo warranto, roughly translated from the Latin, if I got it right, is the whose authority, quo warranto. A petition for writ of quo warranto is an action to challenge the exercise of some right or privilege, the peculiar powers of which are derived from the state. So maybe someone has usurped state power but doesn't legitimately have that state power. That's an excellent use of the writ of quo warranto. But the exercise of any right or privilege that comes from the state, we can challenge the person who's exercising that right via the writ of quo warranto. The writ of mandamus seeks to remedy a government's failure to do something it is supposed to do. It seeks to enforce a clear legal right to the performance of a clear legal duty. What we're talking about here is government inaction, government not acting, government sitting on its duff when it's supposed to be getting things done. Ever seen a government do that? Yes, we all have. A potential remedy is the writ of mandamus, but it has its requirements. It's got to be something the government was supposed to do, and it can't be discretionary. If it's discretionary as to whether the government does it, you're not going to succeed in a writ of mandamus. There's got to be a clear legal right to the performance of a clear legal duty. So if the law is not clear, not going to work. If there's discretion, not going to work. Here's an example. I really like a driver license, but I never took the driver's exam. I'm not going to get my driver license by filing a petition for writ of mandamus. Compare that now to, I'd really like a driver's license. So I studied, I took and passed the written exam. Then I came back for the road exam. I passed the road exam. They told me I passed. They said, come back for a license. I've come back again and again, spoken to every supervisor, filled out every form, but I still don't have my license. Can I get a writ of mandamus then? Yes. But here's the catch, for which license? There's more than one type of driver's license, right? You might have an endorsement for motorcycles. You might have an endorsement for hazardous materials. You might have an endorsement for twins. You might have a restriction. You have to, where'd they go? You gotta wear the eyeglasses perhaps while you're driving. Those parts are discretionary. So in that example, if I succeed in the mandamus, and the relief is always discretionary from the court, all the court's going to grant me is a mandamus saying, give that man a license. Ultimately, I might not get the license I want. It might not have the hazmat, it might not have the twins, it might not have the motorcycle, it might require me to wear the glasses. But those parts I can't fix with the mandamus, because the mandamus will only enforce a legal right to the performance of a clear legal duty. See where I'm coming from on that? And did you notice the pun? I said, see where I'm coming from? My jokes are so bad I have to point them out. Okay. How about the writ of quo warranto? Before Florida's 5 DCAs and 20 circuit courts, that's available to challenge exercise some right or privilege, the particular powers of which are derived from the state. So the respondent need not have state power, but only needs to be using that state power. How about the petition for writ of certiorari? Talked about that very briefly in our lectures. I would encourage you to read up more on it, because it's such a powerful thing if it's available. And there's just one writ. There's just writ of certiorari. But you find it helpful to give that one writ 3 different names based on how it's being used. And the case law helps us along with that. Certainly we see the phrase second tier writ of certiorari in the case law. I've given some more language, and I use that in my book. Where to go? Use that in my book, Florida Elements of Action, found wherever Fine books are sold. And maybe the language will catch on. But let's see what I'm talking about here when I talk about the writ of certiorari. Regardless of the use of the writ of certiorari is used to seek review from an order from which an appeal is not immediately available. So if an appeal can be had from that order, then you can't have a writ of certiorari, any of the three types that we'll talk about. With the writ of certiorari, generally speaking, it's used against an order that departs from the essential requirements of law, causes great, perhaps irreparable harm, and for which no adequate remedy exists. Now, the district courts of appeal have jurisdiction to hear appeals from final judgments or orders of trial courts. But check this out. What if you lose your petition for writ of certiorari and you didn't want to lose? Would you like someone to review your loss of your writ of certiorari? Well, you can't file an appeal from your loss of a writ of certiorari. But you can file a petition for writ of certiorari challenging the failure of the court to grant your prior writ of certiorari. So you file a writ of cert, you lose, can't file an appeal, but you can file a writ of cert challenging the loss of the first writ of cert. What are we going to call that? The case law provides a name. We call that second tier writ of certiorari. Why is it important for that to have a name? Because the standard is different. It's not a do-over. It's not a retrial. For you golfers out there, it's not a mulligan. The standard of review gets harder and harder as you try again. And indeed, that's true on a second tier writ of certiorari. On a second tier writ of certiorari, as you move up that appellate level, each level of review does not become broader, it becomes more narrow. How do you win a second tier writ of certiorari? Only if either one or two. One, the court didn't provide the parties due process. Or two, the court didn't apply the correct law. Look how hard a standard that is. When we say didn't provide the parties due process, and number one, we're talking about procedural due process. What does procedural due process require? Notice, an opportunity to be heard. So if the court gave notice that it was going to act, and you had an opportunity to be heard, maybe you weren't heard, but you had an opportunity to be heard, that's it. That's due process. If you're given at least that, you won't win under the first one. What's the second one? Is that any easier? No. Here, you only win if the court did not apply the correct law. What if the court applied the correct law, but misinterpreted it? Sorry, no relief on second tier writ of certiorari. They applied the correct law. Yeah, they misinterpreted it, but they applied it. So you see, it's not a mulligan, it's not a do-over, it's not a second trial, it's not a redo. As we moved up the appellate ladder, the level of review did not become broader, it became more narrow. So that's a type of certiorari. Let me talk about another type of certiorari. District court certiorari review of local acts. What are we talking about here? Sometimes local collegial bodies or other administrative tribunals will meet a very broad definition that is contained in the Florida Administrative Procedures Act, and they will fall under that broad definition of agency. Agency, as defined in the Florida Administrative Procedures Act, is quite broad and broad enough to cover most anybody. But there are those collegial bodies, those actors, that don't meet the definition of agency. How do I appeal from their decisions? The way I do it is through a writ of certiorari. But this particular writ of certiorari, this review of local acts, because that's what we're talking about. If you didn't meet the definition of agency, we're talking about a local act or a local act. We're talking about the Board of County Commissioners. We're talking about the City Council. This review of the local act via certiorari looks a lot like an appeal, what we might call a plenary appeal. A plenary appeal is that appeal after judicial labor is exhausted and a final judgment has been entered. At that point, the trial court's work is done. In the plenary appeal, the findings of fact are reviewed for competent substantial evidence. The conclusions of law are reviewed de novo. That's how a plenary appeal works, and that's the same standards used in the Circuit Court certiorari review of local acts. So this particular certiorari use looks a lot like a plenary appeal. And this is that exception I alluded to earlier, where the relief is not discretionary. On every other extraordinary writ, you can prove your case, but the court can still say no relief for you. The one exception is the Circuit Court certiorari review of a local act. There, if you prove your case, then you get relief. See, it looks just like a plenary appeal. It looks just like an appeal from a final judgment. Haynes and his progeny hold that Circuit Court review of such a decision is a matter of right and therefore is mandatory, not discretionary. The Circuit Court reviews the decision of an administrative tribunal much as it would upon a plenary appeal. That's our Circuit Court certiorari review of local acts, stated somewhat differently. But there was one last certiorari we didn't talk about. Remember, I mentioned there were three kinds. There was the Circuit Court certiorari review of local acts. There was the second tier writ of certiorari. The third we'll just call certiorari. What's that? Well, that you're familiar with from its abundant use by the United States Supreme Court. That's exercising discretion to review a case. Although it's different under Florida's Constitution, because certiorari is not as broad. It's not a matter of the court just wanting to get involved. There has to be these standards. For an ordinary certiorari, you must prove that an appeal is not immediately available, that the order departs from the essential requirements of law, that the order causes great, perhaps even irreparable harm, and that no other adequate remedy exists. Why such strict standards? Because this ordinary use of certiorari, this third of the three, is the way we review interlocutory orders. Vocabulary. What's an interlocutory order? We talked about a plenary appeal. The plenary appeal came from a final judgment. But before the court enters a final judgment, it might enter a myriad of rulings. It might enter them on paper, a piece of paper called an order. For example, you might have a discovery dispute. You file the request for production, they say it's privileged. You go to court, the judge decides and enters an order, or enters an order for any other thing that is not the final judgment. These orders along the way to final judgment, we're going to call them all interlocutory orders. Can I appeal from any and every decision the judge makes along the way? No. Unless I meet this standard for certiorari review. I might be able to file a writ of cert. Then I can get review of the interlocutory order. But look what's got to be here. Appeal's not immediately available. It's going to be true of all of these non-final orders unless the Florida Rules of Appellate Procedure happens to list that particular non-final order as appealable. It's got to cause great, perhaps irreparable harm. For example, it does something that can't be undone. For example, say it truly is a trade secret. It truly is privileged. And the court errs in this interlocutory order and orders the release of your trade secret, your privileged information, to the other side. You can't unring the bell. You can't put the horse back in the barn. You can't undo the harm from the fact that your trade secret is now known to others. That might be the type of irreparable harm that could convince a court to grant the extraordinary writ, hear it, and maybe or maybe not grant you relief because it's an extraordinary writ and the relief is discretionary. So there are the three types of certiorari. There's certiorari, there's second tier certiorari, and there is Circuit Court certiorari review of a local act. You see, they're all just writ of cert. But look at the different standards. Look at the different proofs. Look at the different uses. That's why I urge different vocabulary. We talked about separation of powers when we talked about government accountability. We then touched upon it again and again when we looked at the three branches of government. And then finally, we had a short but separate chapter discussing separation of powers. We will return to that topic. One of the things we did was we talked about dissension among the branches, and the example we had there was Florida House of Representatives versus Crist. You remember that case? This was the ultimate battle. Charlie Crist was the governor at the time. That's the executive branch. Florida House of Representatives is the legislative branch. And who's going to decide this fight between the legislative and the executive? Or judiciary, Supreme Court of Florida. Ooh, ultimate throwdown rumble. Big fight here. So what is the takeaway? What did we learn from Florida House of Representatives versus Crist? First thing we learned is that the Florida Supreme Court has quo warranto jurisdiction, alleging a violation of the separation of powers. And the Florida Supreme Court has that jurisdiction even after the act has occurred. Second, the necessary business clause of the Florida Constitution, that's among the governor's enumerated powers. Our governor has the power to do the necessary business of our state. What's that mean? Florida House of Representatives versus Crist helps us understand the necessary business clause does not authorize Florida's governor to execute compacts contrary to the express public policy of the state or to create exceptions to state law. What's a compact? It's a contract between sovereigns. Third, unless there is a tribal state compact allowing gambling, remember the sovereigns at issue in this case were the state of Florida and the tribe. Unless there's a tribal state compact allowing gambling, any gambling prohibited in Florida is also prohibited on tribal land. Fourth, by authorizing the tribe to conduct banked card games, that's what the deal Governor Crist struck with them in the compact. By authorizing the tribe to conduct banked card games in the compact that were illegal throughout Florida, and therefore illegal for the tribe, this tribal state gaming compact violated state law. Fifth thing we learned is that the governor's execution of a compact authorizing types of gaming that were prohibited under state law, that was a violation of the separation of powers because Florida's governor lacks the authority to bind Florida to a compact that departed from our state's public policy of legalizing types of gaming that were illegal everywhere else in the state. But wait a minute, isn't the governor deciding the public policy of the state of Florida? No, says Florida House of Representatives versus Crist. The legislature is deciding the public policy in the state of Florida, says the judiciary, says Florida Supreme Court in this battle between the legislative and the executive. So note what didn't happen. The judiciary didn't step up and say, hey, we're the judiciary, we decide the public policy of the state of Florida. No, it didn't do that. It shouldn't do that. I'm glad it didn't do that because it couldn't and shouldn't do that. And it ruled that the governor couldn't, shouldn't, can't do that. It's the people speaking through their elected representatives assembled as the Florida legislature that determines the public policy of the state of Florida, says Florida House of Representatives versus Crist. We discussed sovereign immunity. What's that? That's the right of a sovereign to be immune from suit and to not be sued or pay the judgment if sued. Sovereign immunity, definition. Sovereign immunity or crown immunity is a legal doctrine by which the sovereign or the state cannot commit a legal wrong and is immune from civil suit or criminal prosecution. If we look at Article 10, Section 13 of Florida's Constitution, we ask ourselves, is this Constitution a grant of power or restriction upon power? Look at the language. It says provision may be made by general law for bringing suit against the state as to all liabilities now existing or hereinafter originating. The author of this language presupposes that sovereign immunity exists. Indeed, sovereign immunity is deemed to arise from the common law and not from the Constitution. It's the Constitution that authorizes the waiver, may be made by general law, the waiver of the inherent sovereign immunity. See that? So that raises this question: sovereign immunity, who's immune from what and from who? And I tried to break it down into three separate issues. First, is the state of Florida and or its counties and or its municipalities immune from state law claims? Second, is the state of Florida immune from federal claim? And third, are counties, municipalities, and or entities that they create immune from federal claims? The answer is different in each category. Let's work it through. First, is the state of Florida or the counties, Orange County, Dade County, Miami-Dade County, Hillsborough County, Duval County, name a county, or its municipalities, City of Jacksonville, City of Orlando, City of Tampa, are any of these things immune? Immune from what? Immune from being sued under state law, not being sued under the federal constitution, not being sued under the federal law, not being sued under the United States Code, not being sued under the federal code or federal regulations, the CFR, the USC, the US Constitution. I'm not talking about those. I'm talking about state law claims. For example, Florida statutes. For example, Florida Constitution. For example, a state law basis. Is the state of Florida or its counties or its municipalities immune from that? The answer to that comes from this general rule, this common law immunity. Remember, the author of that phrase in the text of the Constitution had in mind that immunity already existed. What's that immunity? Here's that immunity. Florida state immunity is total, but lesser sovereigns are not. Talking about immunity from state law claims. Florida state immunity is total, but lesser sovereigns are not. Therefore, state of Florida is immune. County's not immune unless it's exercising the arm of the state. In other words, state of Florida has involved a county in doing a state task, in implementing a state law. It has delegated state power to a county, made the county the arm of the state. Now, with that delegation comes that immunity. Municipalities are not immune when performing the municipality's proprietary functions. What does that mean? Proprietary function is the function of a proprietor. A proprietor is someone who owns things. And indeed, municipalities, cities own a lot of things. They own a lot of fire trucks. They own a lot of police vehicles. They own a lot of vehicles that are on roads that can cause accidents, that can run over people, that can crash into property, that can crash into other cars. Not immune from that proprietary function, the function of being a good proprietor, not driving negligently, for example. So this is common law immunity. But remember, the text of the Constitution said the legislature can pass laws to change this. There's a plethora of such laws. Let's look at just one. Let's look at the tort law. Let's look at Chapter 768, specifically 768.28. The state and its agencies shall be liable for tort claims, but liability shall not include punitive damages or prejudgment interests. Give me a second. A little dry, forgive me. Neither the state nor its agencies nor subdivisions shall be liable to pay a claim or a judgment by any one person which exceeds a certain sum. At the time of this recording, $200,000. Or when totaled with all other claims exceeds another higher sum. At the time of this recording, $300,000. That portion of the judgment that exceeds these amounts, well, you can go to the legislature and you can say, hey, pass a special law just for me, awarding me the rest of my judgment. But unless they do that, you're not getting it. Jury said 20 million, gazillion, trillion, billion, gazillion dollars. You're still not getting more than 300,000. And Justice Cantero's dissent in American Home vs. National Railroad spelled out how all this works quite beautifully. Sovereign immunity of municipalities must be construed strictly, whereas immunity of the state must be construed more broadly. Under the common law, the state's immunity was total, but municipalities never enjoyed total immunity from suit. Before 768.28, in proprietary functions, a municipality has the same tort liability as a private corporation. Essentially, the state and its agencies on the one hand, and municipalities on the other, arrived at 768.28 from opposite directions. The state from the status of near total immunity, and municipalities from the status of near non-existent immunity. And from those polar opposite statuses, 768.28 is enacted, and they arrive at the same place. Isn't that cool? I liked it. Don't forget our studies of Pan Am versus Department of Corrections. There, it was held where the state has entered into a contract fairly authorized by the powers granted by general law. The defense of sovereign immunity will not protect the state from an action arising from the state's breach of contract. So we've explored that first issue. Let's now explore the second issue. Is the state of Florida immune from a federal claim? Up until now, we have not discussed the federal claim at all. Now we're going to change focus. We're no longer going to look at state claims. We're going to look at federal claims instead, but just with regard to the state of Florida and its agencies, not with regard to counties or municipalities or entities created by counties or municipalities. We're looking just at the state of Florida and its agencies. Are they immune from federal claim? We know that the 11th Amendment of the United States Constitution tells us that the judicial power of the United States shall not be construed to extend to any suit against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So it would be unconstitutional to do so. But because Florida has sovereign immunity, the U.S. Congress cannot use its powers under Article 1 of the federal Constitution to subject Florida or any other state to suit in federal court without the state's consent. You can see that in the plain language of the 11th Amendment. What it means is that without consent by the state, you can't sue the state for federal claim. But here's the catch. That's consent might be express or might be implied. Implied, if you will, because exceptions arise when the text of the federal Constitution allows the U.S. Congress to abrogate state sovereign immunity, and then Congress passes a law that properly utilizes that power. Implied, if you will, because the state signed on to the Constitution, the text of it allowed the U.S. Congress to do a thing, and it did that thing properly under the federal Constitution. Therefore, we can imply that the states have waived their sovereign immunity. Some examples: the bankruptcy law. You're in court, you're winning the case. You're about to have the judgment entered in your favor, and the defendant says, Your Honor, I just declared bankruptcy, and indeed, the defendant has done that. State law claim stops right then and there. Case stops. Automatic stay. Another example, civil rights. Can the state of Florida discriminate against you, me, and our fellow Floridians based on race, sex, color, national ancestry, religion, creed? No, of course not. Because of the federal civil rights law. And sovereign immunity won't stop that because of that implied waiver of sovereign immunity. So now let's look at that final type of claim. Again, we're looking at just federal claims, but we've already looked at the state of Florida and its agencies. Now let's look at counties, municipalities, and entities they create. Are counties, municipalities, and entities they create, are they immune? Do they have sovereign immunity from federal claims? Municipal defenses, including an assertion of sovereign immunity to a federal right of action, are, of course, controlled by federal law. So this isn't a question of Florida's Constitution. This is a question of federal law. Now, federal law, by including municipalities within the definition of the word persons that are subject to liability for violation of the federal Constitution and laws, the Congress has abolished whatever vestige of the state's sovereign immunity the municipality used to possess. So it was this simple. In the U.S. Code, Congress defines the word person and says that person includes a municipality. Boom. Sovereign immunity of the municipality, gone. Remember how Justice Cantero explained that the counties and the municipalities came to sovereign immunity from a near state of non-existence. That's all the sovereign immunity they had, and then federal law wiped it out. So you see the answer is quite clear. A state's municipal corporations and similar governmental entities are persons under 42 U.S.C. Section 1983, and therefore Florida cities and municipalities lack sovereign immunity from federal law claims. Can the city of Orlando, city of Tampa, city of Jacksonville discriminate against you, me, and our fellow Floridians based on race, sex, religion, color, national ancestry? No, 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 no. Because sovereign immunity won't protect them. Because they're defined as persons under 28 USC section, to 42 USC section 1983. Sovereign immunity, counties, arm of the state test. A county can take on the state's sovereign immunity when the county can prove it is acting as an arm of the state. We talked about that. The arm of the state test allegedly has 3 factors. But here's the deal. The third factor, the case law says it's of considerable importance. And then, almost without fail, if the third factor is met, then it passes. So it's kind of like a 1-factor test. But technically, there are 3 factors, the third of which is of considerable importance. 1, how Florida law defines the entity. 2, what degree of control the state of Florida maintains over the entity. And 3, the third of which, that is of considerable importance, from where the entity derives its funds and who is responsible for satisfying judgments against the entity. If ultimately the state is paying the county's liability, that's of considerable importance under these 3 factors, and almost always that's enough to satisfy the allegedly 3-factor test. We talked about delegation of government powers. Can there be delegation? What's the constitutional standard? Florida's executive branch, legislative branch, judicial branch, all may delegate, but they may not abdicate their constitutional powers. Any delegation of authority requires an intelligible principle to be laid down for the guidance of the administrative official in the performance of his or her delegated duties. We discussed election law in Florida, the home of the hanging Chad, referenced in the Supreme Court of the United States' opinion of Bush versus Gore. We discussed Orange County versus Singh, a 2019 decision from the Supreme Court of Florida that holds that the Florida Election Code, passed by the Florida legislature, and therefore a statewide law, expressly preempts local election ordinances, even of counties. And that's true despite the home rule authority of counties. We also mentioned that Article 6, Section 4 of Florida's Constitution establishes term limits. To the extent that it attempts to put those term limits upon candidates or incumbents of the United States Congress, such as our U.S. senators or our U.S. House of Representative members, that's unconstitutional under the federal Constitution. So the language is still there in Article 6, Section 4 of Florida's Constitution, but it's not enforceable. Why? Because the Florida Constitution itself can be unconstitutional. How can that be? We know under the 10th Amendment to the U.S. Constitution that the powers not delegated to the United States by the federal Constitution, nor prohibited to by states, are reserved to the states respectively or to the people. But we also know that the U.S. Constitution contains a supremacy clause that says that the laws of the federal government are supreme. No state law or constitution to the contrary overrides it. So despite Florida Constitution being the highest expression of state law, and despite Florida's Constitution being a constitution, it itself can have language in it that is unconstitutional if it violates the federal Constitution. We talked about Homestead. Homestead is in the state constitutions of more than 20 states, but is somewhat unique in Florida's Constitution. The Constitution of the state of Florida protects a Floridian's homestead in 3 distinct ways. First, a partial exception from certain real estate taxes. Second, preventing a forced sale in favor of most creditors. And third, preventing the owner from bequeathing or devising property to those who are not related to the owner. Article 10, Section 4 of Florida's Constitution says this shall be exempt from forced sale except for the payment of taxes and assessments thereon. So if you take out a mortgage, if you owe some property taxes, if you get some labor performed on the realty, those creditors can foreclose. But otherwise, you've got some protection. It protects a homestead If it's inside a municipality of a smaller size, if it's outside a municipality of a larger size. It also protects personal property to the value of $1,000. These exemptions inure to the surviving spouse or the heirs, a broadly defined term. Almost anyone's related to you as an heir. Inures to the surviving spouse or heirs of the owner. So when is a Florida home a homestead? Florida Realty is a homestead when it's owned by a natural person who intends it to be his or her permanent residence and who is a legal owner of the real property that meets the size and contiguity requirements of Florida's Constitution. But what if the homestead is jointly owned? Generally speaking, that's okay. Florida statutes provide that a homestead jointly owned via tenancy by the entireties or via joint tenancy with rights to survivorship becomes solely owned by the surviving owner upon the co-owner's death, and does so free and clear of the deceased's debts and financial obligations, except taxes and liens for purchases or improvements to the property. What is meant by the Florida Constitution saying the homestead cannot be devised, it cannot be bequeathed, it cannot be sent to another after death by the estate plan, the will, the revocable living trust? What's meant by the Florida Constitution saying that the homestead can't be devised? Well, that means three things. First, the deceased will or revocable living trust, or whatever the estate planning document name might carry, does not void or avoid homestead protection when there is a surviving child or spouse of the deceased, because it does not control the devise of the homestead when there are such survivors. The surviving spouse inherits, despite any will or trust, one or the other, either A or B, inherits A, choice of a life estate or undivided one-half interest if the deceased's children survive the deceased and they, per stirpes, hold a vested remainder. Or B, if the deceased's children did not survive the deceased, then the spouse inherits the homestead in fee simple, unless the spouse validly waived that right. There's a statute to help us determine whether the waiver was valid. Despite the will of the trust, the surviving children inherit, if no surviving spouse, the homestead in fee simple as tenants in common. What becomes of the homestead if the deceased is not survived by the spouse or minor children? The homestead protection is lost unless the deceased estate plan devises the home solely to one or more of the deceased family members who fall within the class of persons categorized in Florida's intestacy statute. That's the holding of Snyder versus Davis, but we took a look at the intestacy statute, and if there's any sort of relationship, if they're family in almost any way, then they qualify as an heir. We had trouble identifying someone who didn't fall within the intestacy statute. A close friend was the best example we could come up with. We discussed taxation and finance. Article 1, Section 25 of Florida's Constitution creates a taxpayer's Bill of Rights. It says that the legislature must adopt such a thing, and it did. It's long, it's lengthy. Here's three highlights. Taxpayer's Bill of Rights says there's a right to request assistance from a taxpayer's rights advocate who has some true power, the right to be represented or advised by counsel, that's us lawyers, the right to have a taxpayer's tax information kept confidential unless otherwise specified by law, some confidentiality. We talked about various types of taxes. Ad valorem taxation is not available to Florida's legislature, but to those municipal corporations, the counties, the cities, they can enact ad valorem taxation, and only they. This is taxation that's based on the value of property. It's always done as to real property. It can be done as to personal property. Estate taxes, Florida legislature enacted those in such a way that if you don't owe federal tax liability, you won't owe Florida estate taxes. Gross receipts taxes, excise taxes, sales and use taxes were also discussed. But even if you don't have the valid authority to tax, you might be able to impose a special assessment. A valid special assessment must meet two requirements. First, the property assessed must derive a special benefit from the service provided, and two, the assessment must be fairly and reasonably apportioned according to the benefits received. But who decides this? Who adjudicates this? As we know from our study of Morris versus City of Cape Coral, these two prongs both constitute questions of fact for a legislative body rather than for the judiciary. These are not judicial determinations. If you challenge them in the judiciary, they just want to know, were they arbitrary? If they weren't arbitrary, in making these questions of fact. When these questions of fact were adjudicated by the legislative body, then the judiciary will approve them. So if the legislative body does these two things and they aren't arbitrary about it, then the judiciary will not substitute its own judgment. The judiciary will not grant relief. We discussed due process. And Florida's constitutional right to due process looks a lot like the federal right to due process. If I could try to eke out a difference, I might talk about the conclusive or irrebuttable presumptions. Under the federal constitution, a criminal statute cannot contain a conclusive or irrebuttable presumption, but a civil statute can. Under Florida's constitution, neither a civil nor a criminal statute can contain a conclusive or irrebuttable presumption. For the civil statute, it can contain it if it meets this test. The test for the constitutionality of statutory presumptions is twofold. First, there must be a rational connection between the fact proved and the ultimate fact presumed. Second, there must be a right to rebut in a fair manner. Those were the lessons we learned from Hall versus Ricci America and Castellanos versus Next Door Company, two cases that arise under the Florida Workers' Compensation Law, two cases illustrating an irrebuttable or conclusive presumption that was therefore unconstitutional under the Florida Constitution, but would have been constitutional under the federal Constitution. We talked about amending Florida's Constitution. Say you represent a client who doesn't like Florida's Constitution. What can you do about that? Well, remember, you can get a judicial determination that the state constitution is unconstitutional under the federal Constitution. You can litigate your way to a better result, or perhaps you can lobby your way to a better result. Let's look at some options for amending Florida's Constitution. For any state constitution, the rules for amending appear within the state's constitution. No exception here in Florida. Look at Article 11 of Florida's Constitution. You'll find the rules. For any state constitution, state legislatures typically have a role in amending. No exception here in Florida. The role here is a supermajority, 3/5 majority of the Florida legislature, both houses, of course, can pass a law that then becomes a proposal, a proposed constitutional amendment. Another way to amend any state constitution, well, this one's actually unique to Florida's constitution. This is the Florida Constitutional Revision Commission. We've got them meeting every 20 years. Then we've got a budget commission, separate commission, meeting on a schedule. They get together, they enact rules, they create a vote under their enacted rules, and if it passes under their rules, they too have created a proposal. They haven't yet amended the Constitution, but they have a proposal. Another way to amend a state constitution is voter initiative. Is this what gives state constitutions a bad name? Some of the length of the state constitutions can be twice or 3 times or 4 times as long as the federal constitution because of all these amendments that have been passed, because the people, in a very direct way, can draft a law and amend the Constitution and make that law, not through their elected officials only, but through an amendment to the Constitution too. This voter initiative process, that exists here in Florida too. You need 8% on one subject. That becomes a proposal. Again, we haven't amended the Constitution yet, but we've got a proposal, a constitutional convention called by the people. That's another way you could wipe out this Constitution and start again. That results in yet a proposal. But what happens to all these proposals on that cliffhanger? I'll be back in 4 minutes. And in 4 minutes, after a 4-minute break, I'll tell you what happens to those proposals. I've left you on a cliffhanger. Through all these actions, we still have not amended Florida's Constitution. Through all or any of these actions, all we have is a proposal to amend the Constitution. What becomes of all these proposals? How do these proposals become an amendment to Florida's Constitution? What becomes of these proposals is always the same. Regardless of the origin of the proposed amendment, it is submitted to you and I. It is submitted to the people. It is submitted to Floridians. It is submitted to Florida's registered voters. There's a potential that a Florida Supreme Court lawsuit might prevent a vote on it. But assuming that doesn't happen, we get to vote. Pre-election, this proposal runs twice in a newspaper, because who's got the internet? Runs twice in a newspaper in each Florida county. If 60% of the voters approve it, then it becomes effective on the date stated therein, or if none, then it becomes effective on the first Tuesday after the first Monday in the January after the election. Access to courts. Here we studied Article 1, Section 21, access to courts. Like so many states, we have this language borrowed from Magna Carta that does not appear in the federal Constitution. The court shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. But this is more than just the Americans with Disabilities Act copied and pasted into a state constitution. This is more than just physical access to a courthouse. This has become, in many states, Florida included, a right to a remedy, or stated somewhat differently, and especially in Florida, a constitutional protection against the abolishment of an existing cause of action, if that cause of action is protected. Kluger versus White is the seminal case telling us what Article 1, Section 21 means under Florida's Constitution. It's a case worth reading and a case worth knowing by name, whether on my test or on, in my opinion, the Florida bar exam. You can summarize the holding of Kluger versus White any way you wish. Here's the words I've chosen, and I suspect I've chosen my words well. First, if the cause of action existed prior to the 1968 Constitution, then abolishing that cause of action violates Article 1, Section 21, access to courts, unless one of these two exceptions exists. The first exception is short, the second exception is twofold. So abolishing it violates access to courts unless there is a reasonable alternative provided, or unless there's both an overpowering public necessity and no alternative method of meeting that public necessity. This is the holding of Kluger versus White as I would express it. I urge you to read the case. It's short and it's important. So here we are back at the slide where we started. This is the end of our presentation. I hope it's been a profitable and enjoyable semester for you. It's been my goal to serve you well, and I hope I have. Perhaps I've left you with questions. Please reach out to me, contact me. It's always a pleasure to hear from you. Look forward to helping you further if I can. And until we see each other again, may God continue to bless us all. Thank you and good night.